The 16th of July Eswatini deportation. What happened? On the morning of the 16th of July, 2025, 5 men convicted criminals, originally from 5 different countries, were escorted aboard a chartered U.S. government aircraft under heavy ice and U.S. Marshal Service security. The flight departed from an undisclosed military airfield near El Paso, Texas, and landed more than 9,000 miles away in the southern African kingdom of Eswatini nation, neither known for international cooperation nor for receiving foreign nationals with no citizenship links. But this was no ordinary removal. Who were the deportees? According to DHS officials and internal ICE flight records leaked to journalists, the 5 individuals had the following backgrounds. Vu Tran, a Vietnamese national convicted of second-degree murder in California, where he had been a lawful permanent resident since 2002. Kwame Bell, a Jamaican national sentenced to 18 years for gang-related assault and illegal weapons possession in New York. Luis Gomez, a Cuban immigrant found guilty of multiple counts of child sexual assault in Florida. Ali Nasser, a Yemeni national formerly on a no-fly watch list, convicted in Arizona on charges of material support to a designated foreign terrorist organization. He denied the charges, citing entrapment. Chanara Vong, a Laotian refugee with a 1990s-era green card who served a 24-year sentence for manslaughter and had lived in the U.S. since the age of 5. What united these men, despite their diverse national origins and criminal records, was a shared status. They had either lost legal immigration status due to their convictions or had never obtained one. More importantly, none of them were legally repatriable to their home countries, either due to diplomatic restrictions, in the case of Cuba and Yemen, lack of identity documentation, Vietnam and Laos, or unresolved appeals pending in immigration court. Why Eswatini? The choice of Eswatini, formerly known as Swazilandis, puzzling to most casual observers. A landlocked country of 1.2 million people nestled between South Africa and Mozambique, Eswatini is a monarchy ruled by King Mswati III, Africa's last absolute monarch. Its legal system blends Roman Dutch common law with royal decrees and customary tribal codes. Human rights groups have frequently criticized its police force for arbitrary detention, torture, and censorship of opposition figures. Yet in the months leading up to July 2025, senior officials in the U.S. State Department had quietly negotiated a third-party transfer agreement with Eswatini. The terms of this deal remain classified, but a leaked diplomatic cable suggests that the kingdom agreed to temporarily host deportees in exchange for a package of bilateral aid, medical supplies, and agricultural development assistance. It's unclear whether Eswatini has any long-term plan for the 5 deportees beyond detaining them in isolation. This agreement marks the first time that Eswatini has officially accepted foreign deportees with no legal or cultural ties to the country. How the operation was carried out? Details of the 16th of July operation reveal a level of coordination usually reserved for high-risk national security transfers. Secrecy and speed. Deportation notifications were delivered only 6 hours in advance. Lawyers for the detainees were reportedly unaware of the transfers until after the aircraft had landed in Mbabane. Security protocols. Each man was restrained in a full-body transport harness with ankle shackles, wrist cuffs, and in some cases, facial hoods. 2 detainees were sedated mid-flight under ICE medical supervision. Aircraft. The flight was contracted to a private aviation firm based in Texas, specializing in discreet international prisoner transport. Flight logs confirmed the jet made no intermediary stops between the U.S. and Africa. Arrival in Eswatini. Upon landing at King Mswati III International Airport, the deportees were transferred to armored vehicles and driven to a high-security facility on the outskirts of the capital. The Eswatini government later confirmed the arrival of 5 non-citizen individuals as part of a U.S. cooperative security agreement, but provided no additional details about their conditions or legal status. What happens now? Officially, the men are classified by Eswatini as foreign security transferees, a legal term with no clear basis in international refugee or immigration law. While DHS asserts that the deportees were given the opportunity to claim fear of return, i.e. asylum, prior to removal, immigration attorneys dispute this. Several of the men had ongoing habeas corpus petitions in federal court petitions, which were allegedly rendered moot by the Supreme Court's June ruling. In the absence of extradition treaties or formal resettlement plans, Eswatini is now effectively a holding state, charged with managing men it cannot legally imprison nor grant citizenship to. Some observers speculate that Eswatini may try to negotiate third-party transfers to other nations, likely those with weaker governance and minimal refugee protections. This risks creating a refugee ping-pong dynamic where stateless individuals are shuffled across continents without legal process, vulnerable to abuse or indefinite detention. The U.S. government has made no public commitment to monitor the conditions or treatment of the deportees. ICE spokespersons insist that Eswatini has offered credible assurances of humane detention, but no independent agency, UNHCR, the Red Cross, or international press has been granted access to the men since their arrival. Legal pushback and public reaction. The operation has triggered fresh legal action from rights groups, immigrant advocacy networks, and a small number of U.S. lawmakers. The American Civil Liberties Union, ACLU, and Human Rights First have filed emergency petitions in U.S. district courts seeking to challenge the constitutionality of third-country removals. In a press conference, ACLU immigration attorney Kevin Darrow stated, "This administration has now demonstrated that it will remove people to countries with no regard for citizenship, safety, or human dignity. Eswatini is not a solution, it's a shield for a broken deportation system." Congressional Democrats, led by Rep. Alexandria Ocasio-Cortez and Sen. Alex Padilla, have called for an immediate congressional investigation into the diplomatic deals behind such removals. Meanwhile, pro-enforcement Republicans have defended the operation, portraying it as a necessary escalation in the fight against foreign crime syndicates. Public opinion remains deeply polarized. Some Americans, particularly in conservative media, applaud the decision to remove foreign criminals by any means necessary. Others view it as a dangerous abdication of legal and ethical responsibility, particularly when conducted in secrecy and beyond judicial review. Legal shift, the June 2025 Supreme Court ruling. The 16th of July deportation of 5 foreign nationals to Eswatini would not have been legally possible just weeks earlier. It was only through a landmark legal shift spearheaded by a controversial U.S. Supreme Court decision on the 23rd of June, 2025, that the Trump administration gained the power to bypass critical procedural safeguards in deportation cases. This section will explore the background, legal arguments, and implications of that ruling and how it has opened the door to a dramatically escalated third-country deportation strategy. Background: the court case, DVD v. Department of Homeland Security. At the center of the legal upheaval was a class action lawsuit filed by a group of immigration attorneys and advocacy organizations, DVD versus DHS. In response to the Trump administration's attempts in late 2024 to deport individuals not to their home countries, but to unaffiliated third nations. The plaintiffs, representing non-citizens from countries with travel bans or diplomatic conflicts, argued that such deportations violated both U.S. immigration law and international human rights treaties. Key legal claims included violation of the Immigration and Nationality Act, INA, which requires that deportees be returned to their country of nationality or last habitual residence. Violation of due process rights, particularly the right to contest removal and apply for asylum. Violation of non-refoulement, a principle under the Convention Against Torture and the 1967 Protocol relating to the status of refugees, to which the U.S. is a signatory. The Federal District Court in California granted an injunction in early 2025, halting all third country removals and requiring that deportees be given a minimum of 10 days' notice with an opportunity to raise legal objections before a judge. That injunction was upheld by the Ninth Circuit Court of Appeals. But the Trump administration, through the DOJ Solicitor General's office, filed an emergency appeal to the U.S. Supreme Court, arguing that the injunction amounted to judicial overreach into core executive authority over immigration. The Supreme Court decision, the 23rd of June, 2025, in a 5-4 ruling, the Supreme Court issued a stay of the injunction, thereby allowing DHS to resume third country deportations while the case is still pending on its merits. The majority opinion, authored by Justice Neil Gorsuch, concluded, the executive branch possesses broad discretion in matters of immigration and foreign affairs. The INA does not prohibit removals to third nations when such nations have agreed to accept the individual and when the deportee lacks a lawful basis to remain in the United States. The court emphasized that no statutory provision requires that a non-citizen must be returned only to their country of origin. It also cited the plenary powers doctrine, which grants the executive and legislative branches considerable authority over immigration, especially where national security or foreign policy concerns are involved. Justice Amy Coney Barrett, writing a concurring opinion, added that DHS must still ensure that deportees are not subject to torture or persecution, but deferred judgment to DHS's internal assessments. The dissenting opinion, Justice Sonia Sotomayor, joined by Justices Kagan, Jackson, and Roberts, in a rare alignment, issued a blistering dissent. Today's ruling allows the government to remove human beings to countries with which they have no connection, no protection, and no chance to be heard. This court has abdicated its responsibility to safeguard due process under the Constitution. The dissent warned that allowing 6-hour deportation windows and foreign transfers without judicial review risks permanent injury, arbitrary detention, and even torture. What changed legally? Prior to the ruling, DHS was bound by both domestic judicial injunctions and long-standing interpretations of INA Section 241B, which prioritizes deportation to country of nationality, country of last habitual residence, country of entry into the U.S., any country willing to accept the deportee. The fourth category had rarely been used, but under the new interpretation endorsed by the court, any country willing to accept an individual becomes legally valid for removal even if the deportee has no legal or familial ties to the country, no language, cultural, or survival connections, no opportunity to contest the removal. This opens the door to diplomatically brokered receiving agreements with small or authoritarian states willing to accept migrants in exchange for aid, investment, or diplomatic concessions. How DHS implemented the ruling: within 72 hours of the decision, DHS issued Memorandum 2025-87A, revising removal protocols. Advance notice: DHS may deport individuals with as little as 6 hours' notice in exigent cases. Asylum claims: if the deportee has not formally submitted a written credible fear claim, DHS may proceed without a hearing. Legal access. Attorneys need not be notified if the detainee has no active appeals or petitions on file. Receiving country criteria. DHS's own vetting suffices. No external review is required to determine if the receiving country is safe. These new rules became the legal framework under which the Eswatini deportations occurred on the 16th of July. Implications for asylum seekers and green card holders. One of the most far-reaching effects of the ruling is its application beyond criminal aliens. Asylum seekers who cannot be returned to their country of origin due to war, dictatorship, or persecution may now be deported to a third country they've never visited. Lawful permanent residents, green card holders, convicted of certain crimes may lose all procedural protections. Stateless persons or refugees from failed states may find themselves outsourced to countries where international oversight is weak. In essence, the ruling has removed a core legal check on the executive branch's deportation powers, replacing it with internal discretion, a shift that critics call deeply dangerous. International law versus U.S. Supreme Court. Legal scholars warn that the court's decision may violate international law, particularly the principle of non-refoulement, which is enshrined in the 1951 Refugee Convention, the 1984 Convention Against Torture, the International Covenant on Civil and Political Rights, ICCPR. Although the U.S. is not a party to the Refugee Convention's full enforcement mechanisms, these treaties still form part of customary international law, which binds all states. The UN High Commissioner for Refugees, UNHCR, released a statement after the ruling. No refugee or asylum seeker should be forcibly transferred to a country where their life, freedom, or dignity are at risk. Diplomatic convenience does not justify human rights violations. Potential for future challenges. While the 23rd of June decision was a procedural ruling on a stay, the underlying case DVD v. DHS remains pending. Immigration attorneys hope to prevail on the merits, arguing that the removals violate statutory interpretation of the INA. The practice violates the Fifth Amendment Due Process Clause. DHS's internal reviews lack independent oversight and transparency. If the case returns to the Supreme Court for full adjudication, future justices or a different court composition could reverse the precedent. Until then, the administration has legal carte blanche to continue its program of third country removals. What is third country deportation? Origins, mechanics. Third country deportation is not a new concept in the realm of immigration law, but its application, especially at the scale and scope now being pursued by the Trump administration, is unprecedented. This section explains the historical context, legal basis, operational mechanisms, and controversial implications of deporting individuals to countries with which they have no prior connection. Definition. What is third country deportation? In the simplest terms, third country deportation refers to the forcible removal of an immigrant or non-citizen not to their country of origin, citizenship, or last habitual residence, but to a third nation willing to accept them regardless of prior ties. Examples include deporting a Cuban national to Eswatini, sending a Somali refugee to Panama, repatriating a stateless Rohingya individual to South Sudan. These individuals may have never visited, resided in, or held citizenship in the destination country. Historical precedents. Rare and limited. Before 2025, third country deportations were extremely rare, used mainly in three scenarios. Diplomatic deadlocks. For example, when Cuba or North Korea refused to accept deportees, the U.S. occasionally negotiated quiet transfers to friendly third nations. National security concerns. Terrorism suspects were sometimes removed to cooperating states like Jordan or Morocco, often under extraordinary rendition programs during the War on Terror. Safe third country agreements. STEC. The U.S. has formalized agreements, like with Canada, in which asylum seekers can be returned to another country deemed safe for processing claims. However, these were bilaterally negotiated, legally specific, and subject to international oversight. Legal foundation? The legal basis for third country deportation lies in Section 241b(2)(e) of the Immigration and Nationality Act, INA. It allows for removal to any country willing to accept the alien if other preferred destinations are unavailable. However, this provision was traditionally interpreted as a last resort, not a tool for bypassing standard repatriation or asylum procedures. It is the reinterpretation of this clause endorsed by the Supreme Court's June 2025 decision that has empowered DHS to use it broadly and systematically. Why use third countries? The Trump administration has cited several motivations. Diplomatic gridlock. Many home countries refuse to accept criminal deportees or stateless persons. Speed and efficiency. Bypassing extended court reviews accelerates removals. Deterrence. Officials believe the threat of being sent to an unfamiliar and possibly unstable nation may discourage future illegal entry. Cost sharing. Some deals include provisions that shift the cost of detention or resettlement onto receiving countries. Public messaging. Third, country removals signal toughness on immigration, particularly in election cycles. Key partners. Who are the third countries? So far, the known or suspected third country recipients include Eswatini, a monarchic state with no history of international refugee resettlement. South Sudan, a war-torn nation with ongoing ethnic violence. Panama and Costa Rica, seen as neutral grounds though still controversial. El Salvador, already strained by its role in prior migration deterrence deals. Other countries rumored to be in negotiation include Rwanda, Uganda, the Gambia, Liberia. None of these have formally acknowledged or confirmed such agreements publicly, except Eswatini. How the system works. Operational mechanics. The operational flow of third country deportation now follows this structure. Step 1. Identification. ICE or CBP flags a non-citizen for removal due to a criminal conviction, immigration status violation, failed asylum claim. Step 2. Country clearance. DHS attempts repatriation to the country of origin. If unsuccessful, they seek a third country willing to accept. Step 3. Diplomatic contact. State Department brokers the transfer with an accepting country. Terms often include humanitarian aid, investment, or security cooperation. Step 4. Rapid notice. Detainee receives notice sometimes with fewer than 24 hours. Legal counsel may be denied contact during this period. Step 5. Physical removal. Detainees are flown, often sedated and restrained, to the third country. Custody is transferred to foreign authorities. Step 6. Post-transfer status. Host countries may detain, resettle, or seek to deport the individuals elsewhere. The U.S. offers no oversight or guarantees of legal status. Points of controversy. Critics argue that the system violates legal, moral, and procedural norms. Arbitrary transfers. Deporting people to unfamiliar, unsafe countries is considered cruel and unusual. Non-refoulement risks. Transfers may result in torture or death violating international law. Lack of due process. Legal counsel and court review are often bypassed. Secrecy. The agreements are not disclosed, preventing public or congressional oversight. Incentivized transfers. Countries may accept deportees for financial gain, not humanitarian intent. International comparisons. The U.S. program resembles but is even more secretive than Australia's Nauru and Manus detention camps, offshore processing of asylum seekers in Pacific Island states, Israel's deportation to Rwanda and Uganda, controversial 2015-2018 program that ended amid human rights criticism. EU's Safe Third Country deals with Turkey and North African states. In all cases, the externalization of immigration control has raised concerns over human rights outsourcing and erosion of asylum protections. Future expansion plans. Leaked DHS strategy memos reveal ambitions to create a global reception network for third country deportations. Key goals include establishing Deporti hubs in Africa, Central America, and Asia, developing legal templates for expedited transfer agreements, coordinating with international agencies to manage detention and voluntary relocation, and OP. This effort, if realized, would institutionalize a new deportation architecture, one that critics say undermines both national and international legal norms. Conclusion: a new global modeler, a dangerous precedent. Third country deportation has shifted from a fringe exception to a central enforcement pillar. Whether this becomes a template for global immigration strategy or a cautionary tale of legal overreach depends on forthcoming litigation, international reaction, and electoral outcomes. What is clear: the machinery now exists and it has already moved into high gear. DHS, protocols, contracts, and operational secrecy. One of the defining features of the Trump administration's third country deportation strategy is its operational opacity. While the policy shift itself has made headlines, little is known about how deportations are actually conducted, who oversees them, and what mechanisms are in place to monitor the fate of deportees. This section unpacks the Department of Homeland Security's internal protocols, the private contracts involved, and the systematic efforts to shroud these operations from public scrutiny. The black box of DHS deportation logistics. The Department of Homeland Security, DHS, through its agencies ICE, Immigration and Customs Enforcement, and CBP, Customs and Border Protection, is responsible for the logistical execution of deportations. With the introduction of third country removals, DHS has developed a set of classified internal guidelines that are not subject to the Freedom of Information Act, FOIA, due to national security exceptions. These include deportee selection criteria, internal scoring systems to rank removability, risk level, and nationality obstacles, security risk assessment, collaboration with FBI, TSA, and international intelligence on potential threats among deportees. Flight coordination. Scheduling chartered international removals, often routed through military airfields to avoid press and legal interference. Sedation authorization. Medical teams equipped to sedate non-compliant individuals without prior judicial approval. These protocols are governed under ICE Directive 112-50, last revised in 2025, which has not been made public in its entirety. Charter flights and ghost transfers. Unlike regular deportations, which often use commercial airlines, third country removals are conducted through chartered aircraft. These flights are privately contracted to firms such as AeroVantage LLC and Secure Sky Aviation, which specialize in prisoner transport and covert military logistics. Shielded from press coverage, using FAA waivers to avoid flight plan disclosures. Logged under false identifiers, such as non-revenue flights, to conceal purposes. The result is what civil liberties lawyers call ghost transfers, international removals that are invisible to the public, untraceable by lawyers or journalists, and completely controlled by the federal executive. The 16th of July deportation to Eswatini used a Gulfstream G 550 registered to a Delaware-based shell company that had previously contracted with the U.S. marshals for rendition flights to Iraq and Afghanistan. The role of private contractors. A growing share of deportation logistics is outsourced to private firms, often operating under no-bid or limited competition contracts. These companies provide chartered aircraft and crews, medical staff capable of administering sedatives or tranquilizers, private security teams trained in non-lethal compliance enforcement, on-ground transfer assistance at foreign airports. Some of the companies involved in these contracts include Tactic Air International, Global Detention Services, Inc., Falcon Aerospace Security. These firms operate under DHS's Expedited Removal Logistics Framework, ERLF, a contract vehicle exempt from many federal oversight requirements due to its national security designation. Critics argue that this outsourcing creates legal ambiguity, especially when private personnel use force or chemical restraints during deportation. Victims have little legal recourse against private actors operating internationally under federal immunity clauses. Legal access and attorney notification. Under traditional removal processes, deportees and their attorneys are notified of removal dates at least 14 days in advance, allowing time to file appeals or emergency motions. Under the new third country removal protocol, DHS provides no more than 6 hours' notice in some cases. If a detainee has no active legal filings, they may be removed without any notice to counsel. Attorneys often discover removals after the fact, once clients have disappeared from detention rosters. This has led to an increase in emergency habeas corpus filings, many of which are declared moot after removal. Legal advocates say the process violates the Sixth Amendment and the Due Process Clause, especially for individuals with pending legal challenges or asylum claims. DHS data withholding and FOIA denials. Numerous journalists and advocacy organizations have attempted to gain information on third country removals through Freedom of Information Act FOIA requests. In nearly all cases, DHS has redacted or denied documents on national security grounds, classified flight manifests, contractor names, and legal agreements with receiving countries, refused to release medical records, including instances of sedation or physical restraint. In one case, a FOIA request filed by Human Rights First asking for deportation procedures to Eswatini was denied in full, citing the Foreign Relations exemption. This approach has earned criticism from both legal scholars and members of Congress, who argue that DHS is evading democratic accountability under the guise of public safety. Lack of post-deportation monitoring. Perhaps the most disturbing element of the program is the absence of any post-deportation oversight. Once a deportee is transferred, DHS ends all responsibility for the individual's welfare or legal status. No U.S. personnel remain on the ground to track what happens to the person. Foreign governments may choose to detain, release, or redeport the person to even more dangerous countries. The Eswatini deportees, for instance, have been placed in isolated facilities and no international observers have been granted access. The International Organization for Migration, IOM, has not confirmed any role in monitoring or repatriation efforts. This lack of oversight violates international norms on transnational detention, where the transferring state is often expected to ensure basic human rights post-transfer. 7. Congressional and legal pushback. A small group of lawmakers have begun efforts to investigate DHS's role in these opaque operations. In July 2025, Senator Alex Padilla, DCA, introduced the Foreign Deportation Transparency Act, which would require public disclosure of all third country agreements, advance notice to Congress before new transfers, mandatory post-deportation monitoring, regular reporting on human rights conditions in receiving countries. Meanwhile, civil liberties attorneys have filed lawsuits arguing that the use of sedation, private contractors, and accelerated removal violates U.S. constitutional protections, including the Fifth Amendment, due process, the Eighth Amendment, cruel and unusual punishment, international treaty obligations. To date, however, courts have refused to enjoin the operations on an emergency basis, largely citing the Supreme Court's June ruling. The infrastructure of secrecy. Experts in immigration law have coined a phrase to describe what DHS has built: the infrastructure of secrecy. It consists of legal reinterpretation of long-standing statutes, classified bilateral agreements with fragile states, outsourced logistics to private security networks, suppression of public records and media coverage, rapid removal windows to prevent legal interference. In totality, it represents a shadow deportation regime that bypasses not only international norms, but also much of the public accountability traditionally associated with U.S. immigration enforcement. The case of Eswatini, a nation under scrutiny. The decision by the Trump administration to deport 5 foreign nationals to the Kingdom of Eswatini, small, landlocked African monarchias, drawn global attention not just to U.S. deportation policy, but to the nature of the receiving country itself. Eswatini, formerly known as Swaziland, is now under intense international scrutiny. This section examines the nation's political system, human rights record, legal institutions, and role in the third country deportation framework, geography, and governance. Eswatini, located in southern Africa, is bordered by South Africa to the west and Mozambique to the east. With a population of approximately 1.2 million, it is among Africa's smallest countries by both population and landmass. What sets Eswatini apart politically is that it remains the last absolute monarchy in Africa. King Mswati III, who has ruled since 1986, holds unchecked authority over the executive, legislative, and judicial branches. He appoints all key government officials, including the Prime Minister, Cabinet, and top judges. While Eswatini has a constitution adopted in 2005, it does not constrain the king's power. Critics argue that this makes the nation an autocracy with little transparency or democratic accountability. Human rights record. Numerous international organizations, including Amnesty International, Human Rights Watch, and the U.S. State Department, have published extensive reports detailing systemic human rights abuses in Eswatini. Key concerns include arbitrary detention. Political activists and journalists are frequently detained without warrants. Torture and abuse. Detainees have reported beatings, electrocution, and forced confessions. Suppression of free speech. Independent media is severely restricted. Journalists risk harassment, imprisonment, or disappearance. Gender-based violence. Women's rights are limited, and legal protections against domestic violence are weakly enforced. Judicial control. Courts often act in alignment with the monarchy, providing little recourse to defendants in politically sensitive cases. These abuses raise serious doubts about Eswatini's status as a safe third country, a legal standard often used in international law to determine whether deportation is permissible. Why did Eswatini accept the deportees? The precise motivations behind Eswatini's agreement to accept deportees remain opaque. However, sources within the State Department and leaked diplomatic memos suggest several contributing factors. Diplomatic bargaining. The U.S. reportedly offered Eswatini a bilateral assistance package including direct foreign aid, medical supplies and equipment, agricultural technology support, expanded trade privileges under AGOA, African Growth and Opportunity Act. This exchange effectively positioned the deportees as a diplomatic currency, part of a transactional deal to deepen U.S. Eswatini ties. International prestige. For a small, diplomatically isolated country, cooperating with the U.S. can offer international visibility and improved bilateral relations. King Mswati's government may view participation in global security initiatives such as deportation agreements as a way to strengthen legitimacy. Domestic control. With a tightly controlled population and expansive internal security network, Eswatini may believe it can safely detain or monitor foreign individuals with minimal disruption or dissent. Legal status of the deportees in Eswatini. The 5 men deported on the 16th of July were classified by the Eswatini government as foreign security transferees. This label has no defined meaning under domestic or international law. Current reports suggest the following conditions. The men are being held in isolated, maximum security prison units under 24/7 surveillance. No access has been granted to international observers, including the International Organization for Migration, IOM, or UNHCR. Legal representation is unavailable, as the men do not qualify for court-appointed defense under Eswatini law. No public record exists of any formal charges, legal hearings, or pathways to refugee status, asylum, or repatriation. Human rights experts have described the situation as tantamount to incommunicado detention, a practice condemned by multiple international treaties. International reactions. The U.S. decision to deport individuals to Eswatini has drawn harsh criticism from the international community. United Nations, a spokesperson for the UN High Commissioner for Refugees, UNHCR, stated, "Detaining non-citizens in isolated prison facilities without due process may constitute a violation of the International Covenant on Civil and Political Rights. We urge both governments to ensure the rights of the individuals are protected." African Union, AU. Though the AU has not officially condemned the transfer, diplomats from several member states, especially South Africa and Botswana, have expressed private concerns over sovereignty bargaining and the militarization of migration policy on African soil. NGOs. Amnesty International and Human Rights Watch have called for an immediate investigation into the conditions of the deportees and warned that future transfers could amount to de facto renditions. The domestic situation in Eswatini. While the monarchy maintains a tight grip on national media, Eswatini's citizens, especially youth and civil society activists, are increasingly vocal online since the 16th of July arrivals. Local human rights groups such as Pudemo and Swazi Lives Matter have questioned the secrecy surrounding the arrivals. Student organizations at the University of Eswatini have launched petitions demanding transparency and access to the detainees. Leaked photos purportedly showing U.S. planes at King Mswati III International Airport have circulated on Twitter, X, and Telegram, sparking domestic speculation about a secret pact with America. Thus far, no formal protest has occurred, likely due to fear of retaliation from the security forces. Still, tensions are rising, especially among the country's younger, pro-democracy population. Strategic implications for the U.S.? The choice of Eswatini as a receiving country reflects a broader strategy by the Trump administration to circumvent legal restrictions by choosing countries with weak legal frameworks, minimize media exposure by engaging in transfers in regions with little U.S. press coverage, set a precedent for future deals with other authoritarian states, particularly in Africa and Central Asia. However, this approach risks long-term diplomatic and reputational blowback, particularly if the transferred individuals are subjected to abuse or torture, indefinitely detained without trial, redeported to dangerous countries without legal review. Should any of these scenarios occur, the U.S. may be accused of violating international human rights law and possibly domestic statutes such as the Foreign Assistance Act, which prohibits aid to governments engaging in systemic abuses. The future of the U.S. Eswatini Agreement. At present, no public agreement exists detailing the terms under which Eswatini accepted the deportees. However, several sources suggest the agreement is time-limited, with Eswatini expected to either repatriate or resettle the individuals within 12-18 months. U.S. aid to Eswatini is conditional on continued cooperation in hosting special removals. There are no binding human rights clauses or international monitoring mechanisms built into the deal. What happens next, whether the detainees are released, redeported, or held indefinitely, remains unknown. What is certain is that Eswatini is now a frontline actor in one of the most contentious immigration policies in modern U.S. history. Section Sebera: Human Rights, Refugee Law, Global Criticism. The U.S. decision to implement large-scale third-country deportations to nations like Eswatini has ignited an international legal and ethical firestorm. Human rights groups, legal scholars, United Nations agencies, and foreign governments have raised alarm over the policy's violation of fundamental human rights norms, especially those related to non-refoulement, due process, and the treatment of vulnerable individuals. In this section, we'll explore how the Trump administration's third-country deportation program conflicts with international humanitarian standards, refugee protections, and the global rules-based order. What is non-refoulement? At the heart of global opposition to the third-country deportation policy is the principle of non-refoulement, a cornerstone of refugee and human rights law. Under Article 33 of the 1951 Refugee Convention, non-refoulement means no contracting state shall expel or return, refouler, a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened. The U.S. is not a signatory to the Refugee Convention directly, but it is bound by its 1967 protocol and by customary international law, which has recognized non-refoulement as a peremptory norm jus cogens, meaning no state can lawfully derogate from it. Additionally, non-refoulement is also embedded in the Convention Against Torture, CAT, the International Covenant on Civil and Political Rights, ICCPR, the Universal Declaration of Human Rights, UDHR. Critics argue that deporting individuals to countries with known risks of torture, indefinite detention, or violence, like Eswatini or South Sudan, amounts to constructive refoulement, even if the threat does not originate from the individual's country of origin. Bypassing the refugee system, in traditional asylum systems, individuals who fear persecution are entitled to file asylum claims, have those claims adjudicated by an independent authority, access legal representation, and interpreters, be protected from removal until a final decision is made. However, under the third country policy, asylum seekers may be removed without a full hearing if they did not file a timely written claim. Legal access is often denied or rendered impossible due to short removal notice. Individuals are sent to states with no refugee infrastructure, where they may not be able to apply for asylum at all. The American Bar Association, in a July 2025 statement, called this system a deliberate circumvention of the Refugee Act of 1980 and an erosion of the U.S.'s humanitarian obligations under domestic and international law. Human rights groups speak out. Leading global NGOs have condemned the practice in the strongest possible terms. Amnesty International. The U.S. is forcibly dumping foreign nationals in countries they have never visited without legal process or protection. This is a violation of the rights to liberty, dignity, and security of the person. Human Rights Watch. Eswatini's human rights record is abysmal. No deportation there can be assumed to be safe. From International Rescue Committee, IRC. We call for an immediate suspension of all third country deportations until a full human rights impact assessment can be conducted. Other organizations involved in tracking the cases, such as the Center for Constitutional Rights, CCR, and Physicians for Human Rights, PHR, have submitted formal petitions to the United Nations Special Rapporteur on Torture and the Inter-American Commission on Human Rights. Agencies respond. The United Nations High Commissioner for Refugees, UNHCR, issued a rare rebuke. Third, country deportations that result in lack of access to asylum and potential arbitrary detention are incompatible with international refugee protections. The practice must be reviewed and halted. The Office of the United Nations High Commissioner for Human Rights, OHCHR, also warned the lack of post-transfer oversight constitutes a black site system for immigration enforcement. The use of physical restraints, sedation, and private security in removals may rise to cruel, inhuman, or degrading treatment under Article 7 of the ICCPR. Several UN rapporteurs are now investigating the policy as a potential violation of international human rights conventions to which the U.S. remains party. The erosion of U.S. leadership in refugee protections. For decades, the United States was seen as a global leader in refugee protection, having created the U.S. Refugee Admissions Program, USRAP, signed the 1,967 Refugee Protocol, hosted tens of thousands of asylum seekers from war-torn regions annually, provided extensive funding for UNHCR and refugee resettlement NGOs. However, the third country deportation policy has reversed that legacy. According to Georgetown law professor Rosa Menendez, a former State Department legal advisor, we are now witnessing the U.S. actively undermine the system it helped build. Deporting people to authoritarian states without oversight is not just immoral, it sends a signal that any country can outsource its responsibilities. This shift has real consequences. Other countries may follow suit, refusing to process asylum claims and instead paying off weaker nations to take in unwanted individuals. The global refugee system could fragment, leaving vulnerable populations without any viable avenues for protection. The risk to particularly vulnerable groups. Beyond the legal frameworks, there is a human cost, especially for torture survivors, LGBTQ+ individuals, religious minorities, victims of domestic violence or trafficking, mentally ill or disabled persons. Eswatini, for instance, criminalizes same-sex relationships and lacks protection against gender-based violence. Deporting vulnerable individuals there constitutes a foreseeable and grave risk. The National Center for Transgender Equality, NCTE, filed an amicus brief in DVD versus DHS, noting, transgender deportees face a near certainty of violence and sexual assault in the types of facilities currently used in receiving countries. Legal accountability. Can the U.S. be held accountable for these removals? While the U.S. is not subject to the International Criminal Court, ICC, it remains bound by the UN Convention Against Torture, which includes an enforcement committee, the optional protocols of the ICCPR, allowing complaints by individuals, bilateral human rights treaties with several partner countries. Furthermore, victims or advocacy organizations may bring universal jurisdiction cases in foreign courts. For example, the Spanish National Court has a history of trying foreign officials for extraterritorial human rights violations. The German federal prosecutor has pursued cases involving Syrian war crimes. If any deportees die in custody, are tortured, or go missing, the U.S. could be exposed to international lawsuits and reputational damage. Potential policy reversals. Several legal and political developments could halt or reverse the practice. A final merits decision in DVD versus DHS could reinstate judicial review and due process requirements. Congress could pass the Foreign Deportation Oversight Act, mandating transparency and suspending transfers to countries with poor human rights records. A future administration could revoke agreements and implement stronger asylum protections. In the meantime, international watchdogs will likely continue documenting the consequences of each transfer, laying the groundwork for future truth and accountability efforts. Comparative global models: Australia, EU, and Israel. While the Trump administration's third country deportation strategy may seem unprecedented in the American context, other nations have pursued similar externalization policies to shift the burden of migration enforcement beyond their borders. This section explores comparative models in Australia, the European Union, and Israel, analyzing their similarities, differences, and lessons relevant to the U.S. experiment with third country deportations. Australia, offshore detention and Pacific solutions. Perhaps the most widely cited example of third country processing comes from Australia, which since 2001 has pursued a policy of offshore detention for asylum seekers arriving by boat. Key components: Nauru and Papua New Guinea, PNG. Australia paid these Pacific Island nations to host asylum seekers in remote, heavily guarded camps. Mandatory detention. All asylum seekers who arrived by sea were automatically detained offshore, with no guarantee of settlement in Australia. No resettlement guarantee. Even if refugee status was granted, the individual could not be settled in Australia. They might be resettled in Cambodia, the U.S. under a 2016 deal, or remain in limbo. Human rights concerns. Independent investigations documented rampant abuse, suicides, sexual assault, and medical neglect in offshore camps. UN bodies condemned the policy as a violation of international refugee law and torture conventions. Australia eventually closed its Manus Island camp in 2017, but maintained the Nauru operation into the 2020s. Relevance to the U.S. Like the U.S., Australia justified its policy as a deterrence mechanism aimed at discouraging irregular migration. Offshore arrangements were expensive, politically polarizing, and diplomatically sensitive. The human cost was enormous, and domestic legal accountability was minimal due to jurisdictional ambiguity. European Union. Safe third country and externalization deals. The European Union, facing waves of migration from the Middle East and Africa, has implemented its own brand of third country transfer via the Safe Third Country (STC) concept and bilateral agreements. The Dublin Regulation requires asylum seekers to apply in the first EU country they enter, allowing other states to return them to that country for processing, led to massive pressure on border states like Greece and Italy, prompting reforms and legal challenges. EU-Turkey deal 2016. Turkey agreed to accept the return of migrants who reached Greek islands illegally. In exchange, the EU offered €6 billion in aid and a promise to resettle a limited number of Syrian refugees from Turkey directly. Rights groups criticized the deal for undermining refugee protections and enabling arbitrary returns. Migration pacts with Libya and Tunisia. The EU trained and funded coast guards in Libya and Tunisia to intercept migrants at sea. Migrants were often returned to detention camps in Libya, where rape, torture, and extortion were widespread. Human rights concerns. Amnesty International called the Libya policy a form of outsourcing suffering. The European Court of Human Rights has ruled against specific deportations for violating the right to an effective remedy under Article 13 of the ECHR. Relevance to the U.S. The U.S. deportation deals with Eswatini and South Sudan, mirror the EU's practice of externalizing enforcement to weak or autocratic states. Like the EU, the U.S. offers aid in exchange for cooperation, raising concerns of moral hazard and accountability gaps. Both rely on legal fictions of safety in states with well-documented abuses. Israel, covert transfers to Africa, 2014-2018. Between 2014 and 2018, Israel conducted a controversial policy of coerced third-country deportation of Eritrean and Sudanese asylum seekers. How it worked. Israel detained asylum seekers in the Holot Detention Center and offered them a choice: voluntary deportation to Rwanda or Uganda, indefinite detention. Officially labeled as voluntary, the deportations were often coerced with little choice for the asylum seeker. The Israeli government claimed these transfers were bilateral and safe. Investigations and fallout. Journalists discovered that deportees were often not protected upon arrival. Many were denied legal status, forced to flee again, or trafficked through Libya to Europe. Uganda and Rwanda denied official involvement, and the UNHCR condemned the transfers. End of the program. Israel's High Court ordered the closure of Holot and halted further deportations in 2018. The episode remains a case study in how secretive third-country deportations can unravel under international pressure. Relevance to the U.S.? The Eswatini deportation echoes Israel's practice of removing unwanted migrants to authoritarian states under informal agreements. Both involved individuals with no ties to the receiving country. Both relied on plausible deniability by receiving governments and had no monitoring mechanisms. Common criticisms across all models. Despite differences, human rights organizations identify several recurring dangers. Dehumanization. Individuals become political pawns rather than rights-bearing persons. Lack of legal redress. In destination states, deportees lack legal aid, court access, or appeal mechanisms. Risk of abuse. Weak or authoritarian receiving states often abuse or neglect transferred individuals. Erosion of asylum. Shifting responsibility undermines the global refugee protection system. Lessons for the United States. If the U.S. continues down the path of third-country deportations, it can expect to face litigation and injunctions from domestic and international courts, diplomatic tension with countries unwilling to become long-term detention zones, global reputation damage as a violator of humanitarian norms, civil unrest or blowback in receiving states where deportees are seen as foreign burdens. In Australia and Israel, the models eventually collapsed under pressure both internal and external. The EU continues to face lawsuits over its migration pacts. If history is any guide, third-country deportation schemes are ultimately unsustainable without transparency, accountability, and strict rights protections. U.S. political and diplomatic calculations. To understand the full rationale behind the Trump administration's unprecedented third-country deportation policy, one must analyze not only its legal and operational aspects, but also its political motivations and foreign policy goals. This section breaks down the domestic political environment driving the deportation strategy, its use as an electoral message, and the diplomatic calculations shaping secretive deals with smaller, less powerful nations. Political messaging, strong on crime, tough on borders. For Donald Trump and his supporters, immigration has always been a cornerstone issue. From the campaign trail in 2016 to his return to power in 2024, Trump has repeatedly framed unauthorized migration as a national security threat and linked it to violent crime. The third-country deportation policy provides three potent narratives. Deporting the worst of the worst. By focusing early transfers on individuals convicted of heinous crimes, murder, rape, gang violence, The administration builds public support and minimizes sympathy. No safe harbor for criminal aliens. Trump often claims liberal sanctuary cities harbor criminals. Sending such individuals to unfamiliar nations reinforces the idea that the federal government will remove all threats, even creatively. America first, world's problem now. The policy is framed as offloading the burden of non-citizen criminals onto countries that accept U.S. aid, with messaging that aligns with nationalist sentiments. Publicly, Trump has characterized the 16th of July Eswatini deportations as a bold step in taking out the trash and protecting American families. If their home countries won't take them, we will send them anywhere that will. Campaign strategy. Election optics. Trump's re-election campaign in 2024 leaned heavily on immigration. With border crossings rising after COVID-19 disruptions, the administration promised not only border wall expansions and mass ICE operations, but also new removal frontiers. I-90. The third country program served as a deliverable policy win for his base. Rural communities in swing states have been targeted with ads showing mugshots of deported criminals, followed by slogans like, "Trump protected your neighborhood." Law enforcement groups, particularly ICE and Border Patrol unions, have endorsed the policy as giving ICE its teeth back. Media allies like Fox News and Breitbart have run stories portraying the transfers as smart diplomacy and a strong use of executive power. In essence, the deportations act as a visual political device offering tangible proof that Trump is following through on his anti-crime, anti-immigration promises. Institutional support from DHS and DOJ, key leadership within the Department of Homeland Security, DHS, and the Department of Justice, DOJ, have facilitated and encouraged the third country strategy. Acting DHS Secretary John Hawthorne, appointed in early 2025, is a longtime proponent of strict immigration enforcement and architect of the zero-tolerance family separation policy during Trump's first term. The Office of Legal Counsel, OLC, in the DOJ issued internal memos redefining safe removal in ways that lower the evidentiary threshold for potential harm in receiving countries. A DHS memo from May 2025 refers to the third country program as a strategic pivot to asymmetric deterrence, wherein fear of removal to an unknown land discourages irregular migration at the southern border. The bureaucracy has been effectively reshaped to support the political goal of mass removals, expedited removals, and novel legal pathways for deportation. Congressional landscape, partisan divide. Congress remains deeply divided on the third country deportation issue. Republican support, framed as a law and order initiative, endorsed by hardliners like Sen, Tom Cotton, and Rep. Jim Jordan, House Homeland Security Committee praises it as innovative enforcement diplomacy. Democratic opposition, outraged by the lack of transparency and oversight, pushing legislation like the Foreign Deportation Transparency Act, led by figures like Sen, Alex Padilla, Repra Pramila Jayapal, and Sen Elizabeth Warren. Still, no legislation has passed either chamber to formally suspend or regulate the practice, especially given Republican control of the Senate and White House veto power. Diplomatic strategy. The quiet courting of small nations. Behind the scenes, the Trump administration has engaged in a quiet but aggressive diplomatic effort to recruit nations willing to accept third country deportees. Target profile. Small population, authoritarian or semi-authoritarian governance, limited press freedom, dependence on U.S. foreign aid or trade preferences. Eswatini fits the bill perfectly, but so do others currently under negotiation, including Liberia, the Gambia, Rwanda, Papua New Guinea. Bangladesh allegedly approached but declined. Diplomats involved in these discussions have shared that most deals are transactional, involving infrastructure aid, development finance, debt forgiveness, security equipment, intelligence sharing arrangements. One internal memo from the State Department's Bureau of African Affairs describes the strategy as a peripheral partnership initiative that seeks to engage marginal states for burden, sharing on global migration, risks to U.S. foreign policy. While these deals offer short-term wins, the long-term foreign policy risks are substantial, undermining human rights diplomacy. The U.S. loses moral authority when it partners with autocratic regimes to offload vulnerable people, destabilizing fragile states. Adding stateless or criminal deportees into countries with weak legal systems can provoke local unrest or international condemnation. Increased global blowback. The UN, regional bodies like the African Union, and human rights watchdogs may suspend cooperation or funding. Damage to multilateral partnerships. NATO allies and EU states have already expressed concern that the U.S. is setting a dangerous precedent that could disrupt global refugee cooperation. Diplomatically, the U.S. is entering a gray zone where executive action overrides both treaty obligations and traditional foreign policy norms. Public opinion, polarized and volatile. Polling shows mixed public sentiment. 65% of Republicans support third-country deportations, especially for violent criminals. 71% of Democrats oppose the practice, citing human rights and due process. Independents are split, with support rising among older, rural voters and falling among younger urban populations. Key concerns raised in focus groups include: what if we deport the wrong person? Who's watching what happens to them? Will this hurt our standing in the world? Support for the policy is strongest when framed around crime, but weakens significantly when framed around humanitarian impact or global perception. Media landscape, framing the narrative. The media plays a pivotal role in shaping public understanding. Conservative outlets frame deportations as smart diplomacy. Downplay human rights concerns, focus on criminal histories of deportees. Liberal and international press emphasize secret deals, torture risk, and lack of oversight. Use human interest stories of deportees to build empathy, highlight international law violations. Despite some prominent investigative reports, e.g., Washington Post, Politico, AP, the overall press visibility remains low, largely due to classified agreements and opaque DHS protocols. Conclusion and ethical reflections. As the United States embarks on a bold and controversial new frontier in immigration enforcement, third-country deportations to unaffiliated, often authoritarian nations like Eswatini, implications are far-reaching, both domestically and globally. What began as a targeted policy to remove a small group of convicted foreign nationals has now evolved into a precedent-setting architecture with the potential to reshape international norms, undermine human rights safeguards, and redefine the limits of executive power in immigration policy. This final section reflects on the ethical stakes, potential consequences, and core questions the American public and the global community must confront in the face of this policy shift. Human beings, not numbers. At the heart of the third-country deportation debate is a simple but urgent truth. Deportation policies affect real people, not abstract legal categories or national security figures. The men deported to Eswatini may have committed serious crimes, but many had lived in the U.S. for decades, some since childhood, and all faced expulsion to countries with which they had no ties. In some cases, their own nations refused to accept them. In others, documentation or diplomatic status rendered repatriation impossible. Instead of offering due process or supervised repatriation, the U.S. government chose to offload these individuals into a political and legal void of space where U.S. accountability ends and legal limbo begins. This decision speaks volumes about how the state valuer devalues the lives of migrants, even those who have served their sentences and seek redemption, protection, or procedural fairness. The ethics of outsourcing responsibility. Third country deportation represents a form of moral outsourcing. By transferring deportees to countries like Eswatini, the U.S. not only removes them from its soil, but also removes itself from responsibility for what happens next. The act of deportation becomes a legal fiction completed on paper, but the humanitarian consequences are left unaddressed, unmonitored, and unmanaged. Eswatini has no robust refugee system, independent judiciary, or history of rights-respecting governance. Sending vulnerable individuals to such a place is not just legally questionable, it is ethically bankrupt. The U.S. cannot simultaneously champion human rights abroad while outsourcing the suffering of its deportees to countries with known records of repression and abuse. Precedents that could outlive the architects? Policies enacted today may persist far beyond the administration that created them. The infrastructure of third country deportation, built on secret deals, private contractors, opaque protocols, and judicial reinterpretations, could be inherited by future presidents, perhaps even weaponized further in the hands of less restrained successors. What begins with the worst of the worst could soon expand to long-time undocumented residents with minor infractions, refugees fleeing authoritarian regimes, stateless individuals with no recognized nationality, people who speak out or protest from within detention centers. History shows that exceptions become norms, and that unchecked power tends to grow, not contract. International law and America's eroding moral authority. The U.S. has long positioned itself as a leader in global humanitarianism, resettling refugees, funding UNHCR, and promoting human rights. But third country deportation erodes that moral foundation. By violating the spirit, if not the letter of non-refoulement, refugee protection, and international due process, the U.S. is signaling to other nations that human rights are negotiable when political expediency is at stake. Other nations may follow suit, triggering a race to the bottom where global refugee protection collapses under the weight of strategic self-interest. What comes next? The third country deportation program is at a crossroads. Several possible futures lie ahead. Legal accountability. Courts may ultimately rule that the practice violates constitutional due process or international treaty obligations, forcing the government to halt or restrict the program. Political repeal. A change in administration or congressional balance could result in legislative efforts to block funding or prohibit transfers to non-affiliated countries. Expansion and entrenchment. If left unchecked, the program could grow into a permanent fixture of U.S. immigration policy, normalized through repetition and bureaucratic inertia. International crisis. If a deportee is tortured, dies, or disappears in a receiving country, it could trigger international condemnation, lawsuits, or sanctions. Whatever the outcome, the decisions made in this moment will define America's legacy not just on immigration, but on its adherence to human dignity and the rule of law. Final reflection. At its core, the third country deportation program forces a fundamental question. Who are we as a nation? Are we a country that honors due process, values human life, and upholds our commitments to international justice? Or are we a nation willing to disappear unwanted people into foreign prisons for the sake of political optics and diplomatic expediency? The answer may shape not only the future of immigration enforcement, but the moral character of the United States itself.